Get your egos out of the way in this situation. If you're the moving parent, don't insist on taking the kids unless you can absolutely justify the massive upheaval in the kids' lives. One significant issue that sometimes arises post-divorce or post-custody order in something like a legitimation case where the parents were never married is the potential relocation of one of the parents with the children to another state. In Georgia, the law is pretty explicit about the requirements and procedures for such situations. Let's talk about notification of relocation. Georgia law requires that the primary custodial parent provide at least 30 days notice to the non-custodial parent before relocating out of state with the children. So if you settled your case, the requirement actually might be longer, perhaps 60 or 90 days, but 30 days is the absolute minimum required. This notification is a crucial step because it allows the non-custodial parent the opportunity to respond appropriately based upon their preferences and their concerns about the relocation. All right, let me get into some options for the non-custodial parent, and then we'll talk about custodial parents. Once the non-custodial parent receives relocation notice, they face some important decisions. If the non-custodial parent wishes to contest the relocation and keep the children here in Georgia, they must file for a modification of custody. This legal process aims to address the change in circumstances and then determine what arrangement will be in the best interest of the kids. I want to make sure you understand that the court cannot hold back the parent from relocating, only the children. Now, if the non-custodial parent is open to the relocation but wants to adapt the parenting plan to accommodate the new circumstances, they can file for a modification of the parenting plan. This ensures that the amended plan considers the challenges that are then posed by the geographical distance between the parents and the kids and the associated changes in the logistics of visitation with the kids. In some circumstances, the custodial parent seeking to relocate may actually, in fact, be the one filing a petition for relocation with the court in addition to giving notice. The reason for this is that it's a very proactive step on the relocating parent's end, and it gives them the first filer advantage, which I've talked about in another video. If the relocating parent just gives notice, the other parent may file the modification action, and then the relocating parent ends up being the responding party. But if the relocating parent gives notice and files a petition for relocation, they're showing the court that they're not trying to run out of state on a technicality, that being there was no modification filed in opposition to my move. Also, if there is a parenting plan in place and the relocating party takes the kids to another state, there's a chance that a contempt action could be filed for violating the staying parent's right to have the kids as stated in the parenting plan, particularly if that plan is something like a week-on, week-off plan where the kids are being frequently switched between the parents or something else with frequent exchanges. So if you're the staying parent, and you're seeking to prevent the relocation of the children, you do not want to let any grass grow under your feet on this one. Get the modification of custody filed right away with a really sharp attorney who's done lots of these cases before. I have done lots of these cases on both sides, and I'm giving you guys my thoughts on how to handle these situations regardless of whether you're the staying parent or the moving parent. I've already shared that the moving parent should be proactive in notice as well as in filing. Now, what about the staying parent? When I've represented the staying parent, I've always challenged the reason for the moving parent leaving the state. Is it absolutely essential? Is it related to a new love interest? If it's job related, could they not find a similar job here in Georgia? Or are their skills so specific that they can only find work in that new location that's out of state? The courts are going to measure these cases on the best interests of the child standard. In these cases, children are potentially being taken out of their home soil, away from their friends, away from their family, away from schools, community involvements, and away from their parents. So how is the moving parent going to justify this change in their kids' lives in order to get the court to allow them to take the kids out of state? These are not easy decisions, and in fact, sometimes guardian ad litems are tasked with doing a quick investigation and then making a recommendation to the court. Now, assuming that there is a move, either by agreement of the parties or by permission of the court against the staying parent's wishes, there are going to be financial considerations that need to be taken into account, such as the child support modification. Relocation can introduce severe financial challenges, particularly in terms of child support. The non-custodial parent may incur significant additional expenses related to travel, accommodations while in the new location to spend time with the kids, and other costs associated with maintaining a meaningful relationship with their children. In response, a modification of child support might be necessary in order to account for these new financial burdens. It's even possible that the financial burden placed on the staying parent in order to be able to spend time with their children could factor in on the court's decision whether or not to even allow the relocation of the children. How would that be? Well, if the financial burden on the staying parent is so severe relative to their financial situation that the kids lose the ability to see their parent, that could potentially lead to the court refusing to allow the moving parent to take the kids. Now let's talk about timing. It's critical in this kind of case. The non-custodial or staying parent must act promptly upon receiving the location notice. Filing for modifications, whether related to custody, parenting plans, or child support, must be done within a specific time frame to be valid. And in this kind of a case, everything should be handled as quickly as possible due to the logistics involved. Plus, there are two parents and potentially multiple children whose lives are all in pause mode, not knowing whether they should be planning for a future with the kids in Georgia or in another state. So getting the case filed and finalized quickly minimizes the disruption for all parties who are involved. I want to wrap up by telling you this. Get your egos out of the way in this situation. If you're the moving parent, don't insist on taking the kids unless you can absolutely justify the massive upheaval in the kids' lives. Why are you moving? Are your reasons absolutely essential? Would the kids not be better off staying where they are and perhaps you coming to visit often and perhaps having them for longer periods during school breaks or maybe even most of the summer? Okay, now I'm going to turn it on the staying parent. Do you have a really good reason for not letting the kids move with the other parent? Will the kids have a better quality of life in the new state or where they are now? Are you so involved with them now that you couldn't recreate that in a new state, perhaps where they're closer to family if that's the reason for the relocation? And by the way, that's a very common reason for relocation. Both parents are in Georgia, no family, so one of them wants to take the kids to be closer to their family and relatives in the other state. If you're the staying parent, can you justify your reasons for opposing the move of the children? My goal in this video has been to address your concerns and your processes, whether you're the parent staying or whether you're the parent seeking to move with the kids. And it's also been to tell you both to put your kids' emotional needs and other welfare ahead of your own desires or your own egos or even your own grievances that you're still carrying over the relationship having ended some time back. So to wrap it up, no matter which side of the coin you're on, make sure you're very clear in your communication, take timely action, absolutely hire a fantastic attorney who has a thorough understanding of the legal processes surrounding this out-of-state relocation issue. And please try to work it out with the other parents so you can keep the court out of yours and your children's lives. By doing that, you'll have the best chance of ensuring the well-being of your children and maintaining healthy parent-child and even co-parenting relationships. Hey, thanks for watching this video. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos and leave us some comments, ask us questions, tell us what other topics you'd like for me to talk about. Join our Facebook group at Georgia Divorce and Custody for more info. And as always, I look forward to seeing you on the next video.